Hello and welcome everyone to the newest installment of the Project Business Foundation's series on dispute resolution. My name is Martin Berneburg and I am the CEO of this only association addressing all things project business management. As we all know, project management requires a high level of interpersonal skills and stakeholder management in general. When it comes to project business, which means for-profit project management between independent organizations bound by a joint contract, this holds even more true. Because when there is no formal authority of one independent organization over the other, simply escalating disagreements to the sponsor of the own organization doesn't necessarily lead to the resolution of grievances as it normally would in internal projects. As we learned in previous events on the topic, different approaches to dispute resolution are available to project business managers. So today, we want to take a look at how a very high visibility organization, the Olympics, with lots at stake in regards to money, prestige, and legacy, incorporates dispute resolution as part of their project plan and manages individual cases to safeguard against damages to the overall project. With us today are Dr. Peter Heink, construction lawyer and arbitrator from Heink Rechtsanwälte in Stuttgart, who also has a strong background in the legal world of sports, and Sarah Schütte, a projects lawyer specializing in project management from Schütte Consulting Limited in London. Together, they are the perfect team for us project business managers to learn what we can take away from the Olympics approach to dispute resolution. So welcome, Sarah and Peter. Thank you for being with us today.
Thank you.
Thank you.
So before I hand over to Sarah, let me give you all a quick overview of what we have planned today. Sarah is going to lead us into the topic with some preliminary remarks on dispute resolution, followed by the Olympic project's facts and figures, as well as the project's goals. Peter will then take us through specific Olympic case studies with different outcomes. After that, Sarah will make sense of it all by showing us what we as project business managers can take away for our own projects and daily work. After the presentations, we plan to wrap up with about 10 minutes of Q&A, so please submit your questions in the chat during the presentations, and we will look to address as many of them as possible in the Q&A part. So now, without further ado, appreciatively over to Sarah.
Thanks very much, Martin. Hello, everybody. Great to be back with another of our webinars on alternative dispute resolution. So pleased that so many of our members and our friends and some prospective members have joined us today. And I'm thrilled to be working with Peter again on this topic. I hope it's the kind of topic that everybody knows something about, everybody's enjoyed over the past couple of months. So we wanted to do this event while the Olympics is still something that people are talking about and seeing in the press and watching the medalists come home and all of those things. What we do find, of course, is that we've got some, I'm trying to go ahead here, we've got some useful parallels with projects that you as project managers are dealing with. And up on your screens are some of those sorts of things which I think will resonate. We do, don't we, unfortunately get conflicts within our projects, and particularly in project business, because it is involving organizations which are different, which are held together by contracts, as opposed to internal teams that work together. What Peter and I are going to do today is to use the Olympics to propose to you the case which is set out in the middle of the screen, which is how helpful dispute resolution can be to assist you and support you to doing project business. I've given 5 sort of teasers, mini spoilers on the screen there to give you the idea as to how helpful dispute resolution might be to you. We want, don't we, in our projects, swift decisions so that we can keep that momentum, so that we can maintain progress on our projects. We want to make sure that we're using our resources efficiently and sensibly, yeah, so that they're not having to be blocked up later on with things which are in the past, which are stale, which are unpleasant to have to go back to and think about. The great proponent for dispute resolution is to preserve business relationships. As odd as it may sound to say how dispute resolution can be helpful, actually in the moment, in your project, dispute resolution we are going to propose will be helpful to you. Focused efforts and the maintaining of momentum is also about having that eye on the project goal the whole time. What is the driver for success that this group of organizations that has come together to do the particular project has to keep at the front of their mind? And finally, there's an element of confidentiality and business relations in the public realm, an element of reputation management. So we see dispute resolution as being a very useful and structured thing, and as part of risk management as well. There's a quote there, legitimacy through procedure. Those of you who are interested in some of the more philosophical elements of obtaining or determining legitimacy through a procedure can check this out after the event and have a look at that. But we're going to come back to that at the end of this project, this webinar. So let's do a deep dive into the Olympics themselves. Here's a few facts and figures for you. Tokyo 2020. Of course, delayed until this year. Olympic Games and Paralympic Games, huge investment, thousands of athletes coming to the city, all under the banner of unity in diversity. That was their chosen logo for the Olympics. It's a beautiful logo as well, actually. Martin mentioned economic factors as being very much part of the success for the Olympic project. And of course, you know, we have to make investments successful. So we need to look at what success actually means. From my own experience and from here in London, I couldn't talk about the Olympics without mentioning London 2012. And one of the economic factors that we used, and I was involved in the Olympics, was to talk about legacy. And legacy is still something which drives that investment feature for London Olympics. How many people are using the swimming pool? How many go to the velodrome, which is, by the way, fantastic. If you ever come to London, please go to the velodrome. It's a wonderful, wonderful place. What we do find with every Olympics is that we have this time criticality factor, and you have a series of work streams which all come together to one point, as you can see from the little graph, which I have to thank Oliver Lehmann for, our president here at the foundation, because he produced this. And it's a really great illustration of how time criticality matters. And it doesn't matter any more than in the Olympics, which has to come together on that starting date. And you can learn more about this in the Specialist Project Business Managers course, which is something we're going to be talking about another time. But just to look at that, it's going to be something which is really exciting. But all of these separate work streams have to come together for one time, and that's the opening ceremony. So that's one part of the Olympic project. Here's some other parts. 3 important things. First is the USP of the Olympics. Okay, I've highlighted there. The Olympic Games, the world's only truly global multi-sport celebratory athletics competition, etc., etc. That's the nub of it. That's what the Olympics defines itself on. Secondly, the motto that they use, Citius Altius Fortius, Latin, historically strong language. It's evocative, it's meaningful. Okay, and of course, it's international in that sense. And then thirdly, the fundamental principles, which are the 5 there on the screen. And you put all of those things together as principles and project goals for the Olympics. And you have this structured, very definitive, procedurally driven project, which needs to swiftly resolve any conflicts, to preserve and safeguard those things which are at risk. And how this translates into the dispute resolution field is that there is, as it says at the bottom of the screen there, a limited jurisdiction. We call them field of play decisions. That's something that Peter's going to talk further about very, very shortly. So against all of that backdrop, I would like to introduce introduce Peter to you. It's really exciting. We've been working really hard on this. He is our featured guest again. We're very pleased to have him back from the introduction to ADR. So welcome to Peter. Please tell us what is at the heart of all of this.
Okay, thank you, Sarah. So thank you very much. It's great to be here again at the PBF platform. And I will, as you can see now, discuss with you some specific issues about dispute resolution at the Olympics, which is dispute resolution at probably the biggest event you can imagine. And so the question is, how can dispute resolution in a time-critical project work at all? Does it work at all, and how does it work? In order to understand the project-related concept of dispute resolution at the Olympics, we need to look at the Court of Arbitration for Sport, the CAS. The CAS is an institution with its seat in Lausanne in Switzerland, and any person with capacity to effect a legal transaction may have recourse to the CAS. This includes international sports federations, sports associations, sports organizing committees, and other corporations involved in a sports-related dispute. The CAS functions outside of all sports organizations in order to settle sports-related disputes through arbitration. Therefore, CAS arbitration, as with most arbitration, is founded upon contractual agreement. Clauses providing for CAS arbitration are contained, for example, in the Olympic Charter and the Olympic athlete entry form eligibility conditions. So disputes at the Olympics, at the Olympic Games, will be brought to the CAS. But the Code of Sports-Related Arbitration is the institutional arbitration rule of the CAS, and included are procedural rules providing for an ordinary procedure. And as we have to keep in mind, the duration of the Olympic event 2021, Tokyo 2020, was 16 days from 23rd of July to August 8. So as we heard, the Olympics as a project and as an event is extremely time critical. And having said that, we read the procedural rule 31 of the Code of Sports-Related Arbitration. The request for arbitration, the statement of appeal, and any other written submissions, printed or saved on digital medium, must be filed by courier delivery to the CAS court office, and so on. As the CAS main court office is situated in Lausanne, Switzerland, this illustrates that these primary CAS arbitration rules are not designed to fulfill the requirements of dispute resolution during a 16-day event. Therefore, the answer to the question below is no. The Code of Sports-Related Arbitration as such is not suitable for dispute resolution at the Olympics. So what is then the solution? What can we do? In order to fulfill requirements for dispute resolution during the games better, the CAS established the CAS ad hoc division, which functions to settle sports-related disputes through arbitration. And as you can read, insofar as they arise during the Olympic Games or during a period of 10 days preceding the opening ceremony of the Olympic Games. So until here, what we have is a very specific, tailored manner of dealing with disputes during the event of the Olympic Games. Proceedings before the ad hoc division are governed by the Olympic Games rules, which provide for the relevant criteria under which disputes have to be decided. Pursuant to the Olympic Charter, the applicable regulations, general principles of law, and the rules of law. These criteria describe more or less the legal fundament upon which a dispute resolution, in accordance with fundamental legal principles and the rule of law, can be achieved. The decisions are final and binding. And final introductory remark, procedurally, especially the rules listed on this slide guarantee an accelerated procedure at the best possible rate. The arbitrators have to be present at the Olympic Games, even though at the Tokyo Olympics this was not true due to the COVID restrictions. But as we all learned during the pandemic, it was possible to have ad hoc decisions after all. There has to be court office on the site. The names and every data and any other written forms of electronic communication have to be given to the court. Most important, the panel shall give a decision within 24 hours of the lodging of the application. So this is maybe one of the most accelerated procedures we can have at all. As you can see, measures have been taken to ensure that any applicant has a chance to receive an award by the CAS ad hoc division panel quickest possible. The tight time schedule of the Olympic event makes this necessary. We now have a case study for you.
Thank you. Here it comes. I think a lot of that will resonate with project managers, Peter, because they get certainty, they get a swift decision, and then a risk is closed down, and then you implement it. So tell us, these are really interesting. So tell us about the people. Some of these,
yes,
one will relate.
Sarah, that's very true. And we will hear about what is the result and the outcome of having dispute resolution at all at this kind of project. This first case deals with, or is a case that has been well reported in the national German and probably also in the international media throughout the world. The reason that the case is of public interest is mostly probably the political situation in Belarus. So the facts of the case, as you can see, are about Kristina Tsimanouskaya, who is a Belarusian and who had entered the women's 100 and 200 meter track events at Tokyo 2020. Two Belarusian athletes who were going to compete on the women's 4x400 meters relay team had been excluded from attending Tokyo 2020 because they had failed to undertake sufficient doping tests. KT, Ms. Tsimanouskaya, along with another athlete, were added to the Belarusian relay team. However, she posted a video on Instagram stating that she had been included on the relay team without the Belarus Athletics Federation discussing the inclusion with her. After the Instagram video, the Belarusian government TV channel covered the story, stating that the athlete was outraged by being applied to women's relay rather than willing to support the team in a difficult situation. Two of our sprinters were not allowed to compete, not of their making, but because of two strict rules. Instead of taking a chance to win a medal, she resented it before even entering a track. The scandalous runner made it clear that, to say the least, a victory, team success, and spectators do not matter to her. So, consequently, the Belarusian delegation withdrew KT from the women's 200 meter event at Tokyo 2020 and filed or presented a doctor's report on KT's mental and emotional state. And Ms. Tsimanouskaya refuted the findings and made an application to the ad hoc division. She sought an urgent application for the stay of the appealed decision, and as the application was made just 2 hours before the scheduled start of the 200 meter event, the president of the CAS ad hoc division rendered his decision ex parte, that means alone and without hearing the opponent, without appointing a panel. So this is the story about Tsimanouskaya, and maybe you heard about that in the media. And what is the legal background of this case? Please, Sarah, we need the next slide.
Here it comes.
Thank you.
Fascinating, especially when we've been able to see this lady in the media. It was striking, wasn't it, how she extracted herself from that. And then you read, as you said, the TV report from Belarus. I'll let you continue.
Yes, Sarah. Well, I think who saw the media reports has quite an impression of what was going on there. And one can hardly explain every aspect of the story. But from the legal point of view, we have to keep in mind that she sought for a provisional interim relief. And this only can be granted if cumulative requirements are fulfilled, if she has to be protected from irreparable harm, if there is a likelihood of success on the merits of the claim, of course, and in addition to that, if the interests of the applicant outweigh those of the opponent or of other members of the Olympic community. So this is how the ad hoc division has to deal with it, and what is at stake for the project. The Olympic project, as you told us, is a very sensible thing after all. It has to do with economic aspects, with communication, with ethical principles, and with solidarity, neutrality, and after all, with sports, of course, because it's a sports event. And so World Athletics' ability to manage competition in a manner guaranteeing the safety of the athlete is also at stake in this case. So how did the president of the ad hoc division decide the case? As we can see that on the next slide.
While this changes, I think it's very interesting because it was so visible to the public in the press. The process was still visible to the public. At the same time, it was dealt with in a very fast and clean manner, and it ended the conversation. So it wasn't in a situation that was likely to escalate further and basically turn into a PR spectacle. I thought this is a very good example as to how effective the mechanism there actually functions.
Definitely. And we need a body which is impartial and independent, because we have urgency in relation of time. We have political influence, question mark. We have an athlete applying, but not being available for the arbitration panel. And we have facts, but maybe no proof of evidence. So how to deal with this kind of case? The decision rendered by the president was, in the end, maybe not very satisfying from the perspective of a politically thinking member of the society, because one would have wished that Ms. Tsimanouskaya could take part in the event. On the other hand, at least access to justice as a central value still was possible, even though at the time of filing the application, the 200-meter track event was only 2 hours before starting time. And political neutrality of the IOC, which is, by the way, sometimes criticized, still is an objective of the IOC and the Olympic movement. The IOC wants to be neutral, and this objective still was achieved, even though this was not, I think, the intention of the president of the ad hoc division to correspond with the political goal of the IOC, as the ad hoc division, as part of the Court of Arbitration for Sports, of course, is independent and impartial. So after all, we have as a conclusion still fundamental legal principles that apply. And as you can see, after all, one can discuss the outcome, and one can say, I'm not satisfied with the outcome, but we have a very well resonating and very well a reasonable outcome. And this is what you told us about Luhmann and legitimacy through procedure also. We have a procedure and one can bring its case and its state of facts to the court and the ad hoc division. And this is a fundamental legal principle, as the right to be heard has to be fulfilled in this situation. So first case study ends with somehow in between outcome, but not from the legal perspective, because what could be done was done in respect of the participation in the event, and politically spoken, this is actually nothing that the ad hoc division can solve at the time or at all. There are different players and participants in the political game who have to deal with the other sides and aspects of the story. So first case study ends with this conclusion. We have a tailored way of dispute resolution, and one can see the same in the next case study. As you can see, it's about weightlifting. We here have Mr. Agapitov, who is the president of the Russian Weightlifting Federation. And one might think, keeping in mind that Russian athletes have been banned from taking part in international sports events during the recent last years, that the case is quite clear. Well, the case is a special case, as Mr. Agapitov was initially accredited as an official for Tokyo 2020, and he was sent a pre-accreditation card. And so he thought he would travel to Tokyo. Following the issue of accreditation to Mr. Agapitov, the International Testing Agency released a publication which found severe mishandling and impropriety on the part of certain IWF officials in relation to its anti-doping program. And as a result of this publication, the IOC created revised criteria for IWF officials and also Mr. Agapitov to gain accreditation for Tokyo 2020. Among the criteria was a requirement that officials not have a personal history linked to any anti-doping rule violation and or sanction. The personal history criteria. The IOC wrote to Mr. Agapitov stating his accreditation had been withdrawn on the basis he did not satisfy these revised criteria. Mr. Agapitov challenged this withdrawal of his accreditation on the basis it was unfair. Regarding the mention of Mr. Agapitov in a report of Professor McLaren, who is well known to anyone who is interested in sports law, the panel was presented with a written witness statement of Professor McLaren, which highlighted Agapitov's affirmative approach in fighting against doping, support in restructuring the governance of IWF, and his outstanding cooperation with Professor McLaren's report. So this is the story of Mr. Agapitov. The legal background is about basic legal principles. The requirement for precision, clarity, and predictability in the drafting of rules and the description of misconduct, which is likely to be sanctioned, is one of basic legal principles, which especially occurs in criminal law, by the way, because one has to know beforehand what is forbidden if he wants to act according to legal provisions. And at the same time, the principle of ne bis in idem against Latin means no one should be prosecuted or tried for the same acts and for the same criminal behavior again. So not the same time because, or not twice because of the same failure. This is pretty much the meaning of ne bis in idem. And Mr. Agapitov argued that this would be the case. He was prosecuted or had a sanction as an athlete in the past because of a failure, because of a doping, a positive doping test. And he said now he is an official and he is fighting doping, which he tried to make clear through the statement of Professor McLaren. So what is at stake? The Olympic Charter tells us to participate in the Olympic Games, a competitor, team official, or other team personnel must respect and comply with the Olympic Charter and World Anti-Doping Code, including the conditions of participation established by the IOC, as well as with the rules of the relevant IF as approved by the IOC. So we have the World Anti-Doping Code, and the code says you can take part as an official. There is no reason why Mr. Agapitov would be banned from the Olympic Games under the World Anti-Doping Code. And again, the Rule 43 says the same thing. At stake is fair play, fundamental legal principles, prevention of manipulation of competitions. So again, we have pretty high value or pretty high burden on the ad hoc division to decide about this dispute. So on the next slide, we can see what was the outcome of this case. The panel found that the decision of the IOC to withdraw ACE accreditation was not enforceable nor appropriate. And the panel also found the revised criteria set out in the personal history criteria was so vaguely worded and without limitation that it was unenforceable. The use of vague terms such as personal history and excessively loose connection with the sanction without any reasonable limitation with respect to the time or to the person concerned was broad. By the way, one example that the panel made why this provision could not be enforceable was pretty much that if you were a lawyer dealing with anti-doping cases and you are somehow connected with a case because you are the lawyer of an athlete and you try to deal with the case or you deal with the case before the CAS or even before a federation. The wording of the provision Mr. Agapitov tried to fight against here was so broad that even a lawyer trying to deal with anti-doping rules the right way would have to be banned from the Olympic Games because of a, quote, personal history. So if you then see how broad this wording is, it cannot be upheld, actually. And so, as we heard, there is the requirement for precision, clarity, and predictability in the drafting of rules and the description of misconduct which is likely to be sanctioned. This is what we have seen before. And in the panel's view, the provision did not comply with this requirement. In the end, the application was successful. The panel set aside the IOC's decision to withdraw Mr. Agapitov's accreditation and reinstated in full Mr. Agapitov's accreditation for Tokyo 2020. So what we have here is, again, not a black or white case. We have a case where one easily could, at first glance, think we have a Russian official in sports. And I think also it was heavily reported in the media all over the world how Russian officials in sport federations acted in parts in the last years. And there was also sanctions from the CAS and from other bodies against Russian officials and athletes. And so, but this is not the whole story. It is not that we can decide cases upon comparing to other cases. We have to deal with every case, case by case and step by step. And so the conclusion is the panel decided against the IOC, so which can be expected by an impartial and independent panel, and the rule of law instead of a general concern, or let me say general gut feeling, looking at the Russian official in sports, has to come into play. So in the end, and this is true for both cases, and actually, as you can see below here, for both cases and for the dispute resolution at the Olympic Games in general, it is true that by having an instrument or mechanism to resolve disputes, even on site during the Olympic Games, it can be achieved that the economic factor and the fundamental principles under the Olympic Charter are protected, because the main event is functioning, better functioning than the ad hoc division would not be there. And we avoid, or the ad hoc division can help avoiding negative effect on the charisma and credibility of the Olympic movement by dealing with disputes as they occur, and even if they occur in a short-term manner. So this is maybe also kind of a first general summary on what is the special thing about dispute resolution at the Olympic Games. And I think, Sarah, there are so much links between the tailoring of dispute resolution at that kind of big project by having installed a known institution to bring arbitration to the project, to, on the other hand, nearly every project to keep it running and save or secure the project goals.
Absolutely, Peter. Thank you so much for sharing those with us. I hope everybody on this call agrees that they're really fascinating cases that come out of this big Olympic project, where there's so much happening behind the scenes to keep that project moving along in the public realm. And I'm sure that our project managers here will find some of these things resonating greatly with them as they find themselves from time to time, inevitably, at a crossroads on their projects and which way to turn. And here's an emerging problem, or here's a potential risk. And we have to weigh up, don't we, using all those applicable contract criteria in the Olympic sense, all those different factors, the impartiality, the independence, and getting that, as you say, the installed mechanism, which and then everybody respects and relies upon to enable the momentum of that project to continue. So I find some really interesting parallels to the cases that you've brought for the real life projects that our project managers are dealing with. So thank you very much for helping us to make those parallels. I've noted down a few of these, and they are here in sort of takeaways and learning parallels for our project managers. The kind of things that our project managers are dealing with and grappling with every day in projects. And as we say, that momentum for projects needs to keep going. So the legitimacy through procedure, the respect for a contract procedure that enables that project to keep on going is of absolute utmost importance. Preferably, it also needs to be at minimal cost and stress so that we're not distracting from the project at the same time as trying to resolve the matter at hand, and doing so swiftly and respectfully, and all these other factors as well. Of course, the time criticality thing I mentioned up front for the Olympics is absolutely, you know, unquestionable. And whilst some of the projects that we deal with might be said to be time critical, and in fact may have time criticality akin to the Olympics, the main thing is that we maintain that momentum as far as is possible, with the underpinning of this kind of a structure. Dispute resolution then can help to save projects which might be fragile. Yeah, where there are weaknesses potentially being exposed, and where perhaps trust is beginning to unravel as well. And again, that swiftness can help to stem some of the potential issues with the relationship side of things as well. We mentioned Lumen, and I recommend anybody who is interested in seeking further information about legitimacy through procedure will find that fascinating read as well. The key being, of course, that when you respect that procedure through the contract, then there is the minimal disruption and further challenge, and the blocking of resources later on that we talked about up front. On-site dispute resolution is no more apparent than in the examples you gave, where, you know, 24 hours to make a decision. Ms. Timanskaya is at the airport trying to go home. Mr. Agapitov is, you know, hoping to pack his bags and go to the Olympics. And you have these, you know, very urgent demands for dispute resolution, which has to be respected and then be able to maintain that and move forward as well. From my perspective as an advisor to project managers, I love when my project managers feel confident that they're in their pole position. They're very much at the center of projects. This is a real kind of awareness session for them. And it is that balance, isn't it, between thinking, right, crikey, I'm at the center of this project. I've got all these people around me, all of these, you know, different disciplines and expertises that help me to do my job. But at some point, there's the potential for everything just to sort of go, okay, I do now know when to stop and when to get help. And I think Martin's going to give us a few helping hand a little bit later on about that. As always, you and I, Peter, talk about collaboration. It's what we live and breathe in the work that we do, and collaborative teamwork in projects really is everything, isn't it? I mean, there's no more to say about that. And the way that the Olympics comes together is all about collaborative teamwork. So want to sort of end my parallels on that positive note. Now we're about 1/4 which means that we have hit our time critical activities between the three of us. I would like to say thank you again to Peter for having given us those really fascinating case studies.
My pleasure.
I hope it's been some good food for thought for those of you on this call. And we now have a lovely opportunity to have a good session for questions and answers. So I'm going to pass back over to Martin to lead us through those.
Yes, absolutely, and gladly. I find it fascinating, just to throw that in myself, that more and more project managers getting in touch with project business management and dipping their toe in the water for cross-corporate project management. They do really see that dispute resolutions in all its shapes and forms is actually a very valuable tool, whereas before they always thought that, you know, a project runs smoothly, everything is great, everyone does their job, maybe there's a little, well, problem here, a problem there, but generally everything works well. And then the alternative is that something goes wrong, it immediately escalates, and everyone thinks that the only solution is seeing the other party in court. And there is such a diversity of flavors of dispute resolution, how it can work, how it can keep the project moving forward, and making sure that the outcome is good, while problems, disagreements, misunderstandings can be addressed simultaneously, and basically making everything work in a mission success first paradigm. So I think this is really good that this kind of sinks in with project managers who are getting their hands dirty in the high risk, high profit game of project business management, which of course is our core topic. Now, that having said, there is a really interesting story or interesting question from Cor from South Africa. And this is probably for you, Peter. Here's the question. Was the same ad hoc process applied to the Paralympic Games, which followed the Olympic Games? Is that generally the case?
Well, as we heard, we need a legal foundation to bring the dispute to the ad hoc division. And so we have the ad hoc division for the Olympic Games, and the Paralympic Committee had to ask, or had to try to bring the legal foundation that also the Paralympic Committee will bring every dispute to the ad hoc division, and there is an installation of an ad hoc division during the Paralympics. So we didn't have that at the time. So we have several cases where the Paralympic associations and also the committee is involved, and but these cases were dealt with by the ad hoc division of the Tokyo 2020 Olympic Games, as athletes sought to be eligible or to be admitted to the Olympic Games. So this is a different story. The question is if the ad hoc division also has a jurisdiction of the Paralympics. So the answer until now is, from my point of view, no, because but I'm actually not sure if they installed it now currently this year, but before the Tokyo Olympics we haven't seen that.
This is very interesting. Okay. I have a more general question here, and that is, how might a project manager decide when a problem is becoming a dispute, and therefore when to seek help? Basically, where's the threshold where it is within the realm of manageability by the project manager, and when does he or she actually have to make that decision to get external help, either within his own organization at first, and talking to maybe the legal department, or actually seeking external help in, for instance, a scenario of mediation, and etc. So where is that threshold? How can a project manager decide when that problem is becoming too big to handle?
Shall I have a go at answering that? Because I get this question often from project managers who are clients of this firm, as well as when I'm working within a team, and you have those ad hoc conversations with people. And a lot of it comes down to trusting your gut instinct, which perhaps is an odd thing for a lawyer to say when we are, as Peter explained, quite precise people and quite rule following and encouraging of correct process and the like. But I think there comes a point when anybody in any profession gets to start to feel like they're a bit unconfident, a bit out of their depths almost. And I think there's no hard and fast rules, but your gut is a good place to start. And the next place to start, of course, is to talk to someone else. And Martin, I think, you know, other people in your organization is that right starting point. You can, of course, and should, of course, in many cases, then also go and talk to the legal department within the business, because ultimately they're going to be able to look at it a bit more objectively, because they're advisors to the whole business, not just to the project, and be able to look at it fairly objectively and to guide you through and say, look, this really is something where we ought to be supporting you. It might be just a bit ad hoc, or it might be a little bit more formalized or a bit more rigorous in a facilitative and supportive role. You know, project managers have to deal with an awful lot, but we shouldn't burden them with having to deal with everything all the time and expect that expertise in every area is possible, because, you know, I know some super good project managers, and I'm afraid that even the best of you couldn't possibly be experts in everything, and nor should we expect it. So the feeling that you're getting a bit out of your depth, or things are getting a bit on top and a bit overwhelming, I think is absolutely the point, just to stand back and say, gosh, right, I have to be confident to know that I'm not on my own here, and to go and get some help.
Yep, sounds perfect. Then we have a question from Rob, and it goes like this. Does the CAS only cover disputes with activities directly relating to Olympic sports activities, or would they also cover support activities? He clarified then the question further by asking, could be a simple thing like a dispute with a catering contractor at one of the venues, or perhaps some issue with the sports equipment or an adverse incident at one of the venue facilities?
Yes, it's a very interesting question, Rob. I saw it in the chat already. The answer is you need a contractual basis for jurisdiction of the CAS and the CAS, of course, also the CAS ad hoc division. So the CAS has jurisdiction as it is written in the arbitration rules of the CAS on sports-related disputes. But I cannot think of one case where the CAS decided we don't have jurisdiction because it's not sports-related enough. So the answer is, as long as the parties agree on a contractual basis, then if they are commercial partners, they have to agree by implementing an arbitration clause into their contracts. And as long as they agree on that, they can tailor their dispute resolution by giving jurisdiction to the CAS. So this would be possible as long as they agree on it in the contract. Still one thing to add, because sports-related disputes are, you can understand it in a very broad manner. And this is also suitable to have the CAS sitting on that broad understanding of sports relations. But at the same time, we have the legitimization or legitimacy through procedure, that we have the procedure itself, but it's also true that we have that special body of sports experts deciding on cases coming from the world and from the factual basis dealing with sports. So that you have an arbitral panel sitting on your case, understanding the facts. So I think it is sensible to think beforehand if the factual basis is suitable to bring it to CAS or bring it to a commercial body of institutional arbitration like whatever, ICC or German Institution of Arbitration, or there are a lot of institutional bodies providing for arbitration. So this has to be dealt with beforehand. Rob, I hope this answers your question.
Okay, that was also a very interesting answer, specifically in regards to areas that might not seem like a sports-related concern, then still possibly being addressed by CAS. So this was an unexpected answer for myself, actually. Let me phrase a follow-up question. How do I'd say how does the Olympic project actually work with, like the construction projects that go along? How do they work with those contractors, etc.? Are those completely independent projects in themselves? Or might they all fall under CAS if CAS trusts that would be something that they should be attending to?
Maybe they could in theory. Actually, in practice, they won't bring it to CAS because CAS is a special body where experts coming out of the world of sports are sitting over the cases, and they have experience in sports law, which still is a very special materia to deal with. And if you have a construction contract and an infrastructure project, you would bring your upcoming and evolving dispute to a specialized body, maybe a standing dispute board where an engineer and also a lawyer sitting, having experience with the factual basis of construction. So this is a very different thing. So what is the suitable kind or suitable way for your project to deal with disputes, sorry. This is really a thing you have to think of beforehand, and it doesn't make sense to bring your own sports dispute to a standing construction dispute board and the other way. Yeah. So.
Yep. Then I have one final question, which I think is a good last question, and that is, what confidence building can project managers take from this session with regard to dispute resolution to apply to their daily jobs? Maybe that's perfect for you, Sarah.
I think, yes, it probably is actually. And it ties in really neatly with probably everything I hope that we've talked about today, but particularly Peter's point just made, which is, of course, when you create that contract, you can choose how you want to have your disputes resolved. You don't take a construction contract dispute to a sports expert and vice versa. You take it to an appropriate tribunal with an appropriate time frame, with appropriate experts that sit on it. And I think the principle and the nub of that whole thing is about confidence giving to project managers that should a problem arise, should a risk event occur that is going to potentially impact or harm their project, that firstly they know they've got a place to go, and we already talked about the gut feeling and the getting help thing, but also that actually the contract has inbuilt to it a procedurally, structurally sound mechanism that is going to work, that is going to step in should it need to. And of course, one always hopes that it isn't needed. We don't enter into projects, do we, thinking, oh, well, in a few months' time, or, at some point in the future, then, we'll use this mechanism. We don't approach projects like that, but we have it there as a cushion of protection for the parties, of the ability to maintain momentum, which is that driving force to project success. And I think it's that project managers can take as a positive from dispute resolution procedure existing in their contracts, to know that it's going to be there to help them should the need arise.
Perfect, thank you. Now, while I add something to that, maybe you can switch to our last slide while I say, obviously, the Project Business Foundation works with the experts in dispute resolution and alternative dispute resolution, such as, yes, such as you, Sarah, who are a good friend and part of the Project Business Foundation, and obviously you, Peter. And if you out there have a specific situation that you need advice on, that you might need true help in, please do reach out to us. We do make the connection, and we will be at your side to find the right person to help you, such as Sarah or Peter. Do reach out to us via email, and we will certainly help you find the right approach. Now, that being said, thank you very much, Sarah and Peter, for this engaging and enlightening presentation. There were so many takeaways for us project managers on such a crucial topic. And of course, a big thank you to all of you, our audience, for attending and participating with your questions. We certainly invite you to stay in touch. After all, we have a very active LinkedIn channel and invite you all to follow us and our posts. And we are always looking for our community's active participation, comments and feedback on LinkedIn. You can always reach us at info@projectbusiness.org or via our website, www.projectbusiness.org. So do stay close to us. Come join us. You can join us, become a member, and receive access to exclusive offers and benefits. So don't be a stranger. Join the community and your fellow project business managers at the Project Business Foundation. So thank you very much, and see you next time.